Today I'm going to give a presentation on Chapter 4, Part A of the chapter involving classification of the law, included in the book Introduction to Paralegal Studies, A Critical Thinking Approach, 5th edition by Currier and Eimermann. I've divided this chapter into two presentations. This first presentation, as I pointed out, is Part A and covers in the textbook of Chapter 4 the section of the text that's labeled Part A. It begins on page 61, just for your reference if you'd like to follow along. My usual warning, be sure you use the textbook to complete your thoughts about your learning in this chapter, and not to rely solely on this presentation for the quizzes or tests. The quotation for this chapter is one that it took a little time for me to really decide why the author has this as the introductory quotation for the classification of the law chapter. And I began to realize over time, as I got questions from students throughout the program of courses, that this chapter is invaluable to your legal thinking, particularly in the area of problem solving, because the initial threshold question, I believe anyway, is when I should say the initial threshold question when determining what type of problem do we have of this client's. We may understand the source that it comes from, but really it's knowing whether or not it's a federal or a state question. That's a threshold question into how we were going to search for a solution to a client's problem. This chapter as a whole covers these three areas of learning. The first, Part A, is federal versus state law. The second, Part B, is criminal versus civil law. And the third, Part C, is substantive law versus procedural law. As I've already pointed out, this presentation is only going to cover Part A, the federal versus state law topic, and Parts B and C will be covered in a separate presentation. This chart is an illustration of how the law is classified. At the top of the classification system is the state law and federal law, and you can see they're intertwined. In certain respects they are, and we're going to cover a little bit of that as we work through this Part A lecture. In both cases, state law and federal law, they each have some things in common. Two of those things are that they both consist of civil law, which are obligations and rights among people, and criminal law, which are obligations toward society itself and the rights of society with regard to criminal activity. So in other words, we have civil and we have criminal veins that belong within both state and federal law. In both the civil and the criminal strains, we have substantive and procedural law. As you can see, criminal, substantive, and procedural. Below each of these blocks, substantive, they give some examples of what substantive law is in light of the civil law area of classification. Torts, contracts, property, etc. There are a lot of areas that we consider substantive law. It's really the law itself. Procedural law is more of the technicality type of law. When you hear things like, this person got off on a technicality. got out of liability or something to someone on a technicality. We might be dealing with procedural law. Statutes of limitations, that's something we'll discover more about as you work through the chapter, is an example of procedural law. Substantive law, in the criminal vein, is battery, larceny, trespass, many others, and that's substantive law. That's the law itself. Whereas procedural law in the criminal vein becomes more of the technicality areas. Miranda warning, right to an attorney, search and seizure. These are elements of criminal law, but they are more the technical, what is the right thing to do as far as the police is concerned. So next, a short summary of the federal versus state law. Each of the 50 states and the federal government has its own legal system. We know this is true, and we have covered this already in a previous chapter where we learned about federalism, a system of government that operates with a large central government and then smaller regional governments, each able to make their own laws. And again, as I pointed out in the previous discussion about federalism, that is through the 10th Amendment of the United States Constitution. And you can look in the back of your book again and look at the chapter or the appendix with the Constitution in it, and see that Amendment 10 of the United States Constitution says, powers retained by the states and the people. The power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states respectively or the people. When federal law applies is what is often the jargon of legal professionals, and we call that a federal question. A federal question means that the client's problem deals with any of the following. It's a U.S. constitutional issue, it's a federal statute, or it's regulations of a federal agency. This is also outlined in the book on page 61. But very generally, this is exactly what is meant when you hear someone say, oh, that's a federal question. They're saying that the problem raises a federal issue, and to raise a federal issue, it must fall into one of these sources of law, which relates back to chapter 3, when we talked about sources of law. Now, with this federalism system of government, where the authority is split between the nationwide central government and then the several regional governments, we run into conflicts, because the founding fathers, when writing the Constitution, they wanted to limit the powers of the federal government. And therefore, the United States Constitution sets out specific limits of powers, and it says in the textbook, that is, on page 61, the federal government is limited to those powers that are delegated to it in the United States Constitution. Now, these limits of powers may seem limited in scope, but in true practice, societal changes and the needs of society are sometimes, faulted as reasons why there is a need for the federal government to carry out more broad powers. And at this point, I would note that in the course, and I'm pretty sure in this lesson, I have inserted a Annenberg Foundation video that I found on the internet, and it is the Constitution, a conversation. I think that's as simply titled as it can get. And Justice O'Connor and Justice Breyer of the United States Supreme Court have a conversation with some students at a university. It is found outstanding, and it has some excellent examples of how, for example, war has attributed to situations where the interpretation of the Constitution is different as opposed to non-war times. Another example, well, they give several examples, but I hope that you'll watch that video, because it is worth the 35 minutes of time it takes. It's outstanding, and will help you with some clarity in many respects as far as the Constitution. It's not too dry. It's really quite good. So on that note, the excessive reach of the government is often criticized, and because of these limits that the Constitution sets out. Article 1, we talked about that in Chapter 3. Article 2, Article 3, these set out the limits of the federal government's involvement and designs this system of checks and balances. However, our founding fathers did not want the government to have ultimate authority to regulate everything. Our founding fathers wanted the federalism with the authority being split. So the states will be able to manage what's closer at home, or closer to home. And I would add that film that I talked about from the Annenberg Foundation, the Constitution, a Conversation, has a very good example of how closer to home may be, in some people's opinion, a better way of making laws than to leave this into a very large national government strategy, which we don't have. The necessary and proper clause of the United States Constitution is where Congress has permission to legislate, and as stated in the Constitution, to make laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution, or any department or officer thereof. And here's the citation. The citation is where you can look in the United States Constitution and read those very words. If you go to the United States Constitution, Article 1, Section 8, subsection 18. So do that real quick in the back of your book. You can go to Article 1, and Article 1, of course, is going to say the legislative branch, and then there's Section 1, and Section 2, Section 3 covers the Senate, Section 4 covers the organization of Congress, etc., etc., and then Section 8, conveniently, is titled Powers Granted to Congress. And then if you look into the subsections, they're the numbered sections that follow Section 8, and you go to Section 18. I'll pause a moment so you can find that. Alright, so the United States Constitution, Article 1, Section 8, subsection 18 reads, "To make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or to any officer thereof." Alright, so the specific and implied powers. Specific, if in reading the Constitution, there are times when the courts are wanting to interpret what are the powers of the United States government, of the federal government. And we'll find there is case law that uses terminology called enumerated powers and implied powers. Well, enumerated powers are those specific powers stated in the wording of the Constitution. And that's part of that section 8, subsection 18. There are specific powers stated for Congress, for example. All right, now there would be powers granted to the other branches under those articles. But right now our focus is on the powers granted to Congress. And there are implied powers, powers that are broadly interpreted under the necessary and proper clause. In other words, it's sort of it reminds me of a job description. As if you've ever been given a job description at work and it says, well, you need to, let's say the job is for a paralegal. You need to communicate with clients about the status of their case, maintain a docket system, draft documents, do research, blah, 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 blah. And the last item just happens to say anything else that your boss says you need to do. Those are implied powers. Those are implied job responsibilities. And as a result, and that's the analogy I'm trying to make, is that there are specific enumerated powers of Congress and implied powers of Congress. And again, if you read Section 8 and the subsections of that Article 1, you kind of get an idea of all of the specific powers. Okay. Now, for years I've taught this class, and I remember the first few times I taught it, I just really didn't, I was kind of, they gave such short, the authors give such a short explanation of what I just told you, the specific and implied powers, those that are, the doctrine of implied powers, and how that relates to the government and the United States federal government not having as much power as to be the only lawmaker. And as a result of that, on my own misunderstanding, I want to take a minute to sort of focus on this concept before going into the textbook pages 61 at the bottom, through all the way through the end of 63, I believe, and even a little bit into 64. Just as a general understanding on those pages of the textbook, the authors discuss a lot about a lot of different cases, and it would be really very simple to just want to ignore that and wonder, why is this such a vital aspect as to pick up on 4 pages of a textbook on it? Do I really need to know that? And so you're led to believe you must memorize all of this for some reason. Well, I'll tell you, for my class, you don't have to memorize all of this. The point that the authors are wanting to make is to give you some examples of what I pointed out earlier, how society and society's needs have a tendency to bring about the presumed need, and not everyone agrees with this, and so it's an example of our politics as well. That the federal government may be limited, but there may be in practice societal changes and needs that attribute to the needs of the federal government to carry out more broad lawmaking powers. And that's why I titled this slide "Laying a Foundation," to explain to you that there are specific powers pursuant to the United States Constitution. If you look at Article 1, Section 8, you can read what those specific powers are. A few of them are taxation, establishing post offices, raising armies, etc., that I have outlined right here. But as I pointed out, sometimes there's a need to take that understanding a little bit further. And that's what I think the authors are wanting to do, and it is important to at least understand this theory. There is a case, for example, of McCullough versus Maryland, and it's a case from a long time ago. And this case is from the United States Supreme Court in 1819. And in 1819, the United States Supreme Court decided that the Constitution does not explicitly delegate the power for national banks. All right, so if you read the Constitution, you may not see an explicit delegation of the power given to United States Congress to establish a national bank. The expressly delegated powers sometimes create implied powers. And what happened in McCullough versus Maryland is the court looked at the Constitution, because remember, the court's job is to interpret, one of their jobs is to interpret the law. And when someone doesn't understand what the Constitution says or means, and maybe the United States government is doing something, in this example of McCullough versus Maryland, establishing a national bank, maybe a group is not comfortable with the government having enough, that the government has enough power, so they ask the United States Supreme Court to interpret the law. And they do. They interpreted the Constitution in this case, and they found in their interpretation that the Constitution does not explicitly delegate the power for national banks, and the expressly delegated powers sometimes create implied powers. So something may be expressly delegated, and it doesn't say in the Constitution exactly this, but because of these expressly delegated powers, there are some implied powers of Congress. And that is what McCullough versus Maryland is explaining. It's a court opinion where the United States Supreme Court in the year 1819 made a decision and said that the Constitution does not explicitly delegate this power. But, as a legal principle, although not explicitly delegated, powers can be created by the implied powers can be created. All right? So that's an example of how the United States Constitution, in one certain case of McCullough versus Maryland, has been interpreted by the United States Supreme Court. In addition, in this chapter, in this lesson, I have set up a link to a video on demand about McCullough versus Maryland. Okay, from the previous slide, you know now that the doctrine of implied powers was decided as a viable law, a legal principle in McCullough versus Maryland. Now we're going to switch gears to the Commerce Clause and take on those examples of the Commerce Clause that are discussed on pages 62 and 63 of the textbook, and at the top of 64. And my goal here is to just distill this down to what you really need to understand about what is all of this text on those 2.5 pages. Again, Congress uses its powers conferred by the Necessary and Proper Clause to make laws. So they have this power. Over time, the Supreme Court, the United States Supreme Court, has used it in construing, the Necessary and Proper Clause, in construing the Commerce Clause. Okay? So our foundation on the Necessary and Proper is made, but the Commerce Clause comes into play now. Let's look at the Commerce Clause. The Commerce Clause is in the same Section 8 of Article 1 of the United States Constitution. And if you scroll down to Section 8, subsection Section 2, subsection 1. I may have, I do have, this is cited incorrectly. This would be Section 8, subsection 3. Alright, subsection 3. So it's still Article 1, Section 8, subsection 3. And it reads, to regulate commerce with foreign nations and among the several states and within the Indian tribes. So what they're doing in this textbook is describing to you how this necessary and proper clause was used by the U.S. Supreme Court to construe the Commerce Clause differently in different cases. All right, so in each case of the examples that follow, you're going to see how the United States Supreme Court has construed the meaning of the Commerce Clause. And this Commerce Clause thing is big in law school. All they talk about. I mean, it really is big. And we're also going to look at it with that piece of history involved. Okay? So therein comes another principle that's important. In the 1930s, the United States Supreme Court looked at the Commerce Clause, and in several cases, all right, many cases, and in fact there was a lot of regulation of commerce during the 1930s. And that's because, why? We had the New Deal. There was a lot of economic legislation on the federal level and the state levels to deal with, bringing back to life our country. And in addition, because of the 1930s were so expansive in areas like employment, because we were growing like mad, there were a lot of people going to work and a lot of employers taking advantage of people. So the Commerce Clause in the 1930s, when the Supreme Court looked at legislation, and because laws on the federal government laws were being challenged for overreaching into the state's duties too much, they were more the United States Supreme Court was more acquiescent to those laws that deal with economic legislation and labor standards, for example. So when the United States Supreme Court was asked to interpret the United States Constitution's Commerce Clause in relation to areas of law like economic legislation and unfair labor practices, for example, they had a more expansive reading by saying the necessary and proper clause gives Congress the authority to make these laws. And they give some examples that follow in the textbook. All right, so there's one example of the Commerce Clause. Other examples in the 60s. So now history has the Civil Rights Act, and Congress made it unlawful to discriminate in public accommodations. So when cases, for example, the case that's given as an example in the textbook, and I've cited it, the name of it anyway, right here, Heart of Atlanta versus the United States, the free flow of commerce means people were traveling from one state to another. And discrimination, even at the Heart of Atlanta Hotel, was going to thwart this objective according to the United States Supreme Court. So the United States Supreme Court was interpreting the United States Constitution in relation to a law that basically permitted discrimination. And in permitting that discrimination, the United States Supreme Court said, no, we can't permit that discrimination. The objective of our country is to allow free flow of commerce. So state A, state B, Wyoming, Colorado, all the states of the United States need to be able to make money, to go from one state to another, because by this point transportation was huge. We had more transportation. We had more ability to go from point A to point B. We could ship products from one state to another more easily than it was. So as the growth of the United States went on, and that's the historical context, the United States Supreme Court said, look, we need to have a more expansive reading of the laws that Congress can make. And Congress said we cannot discriminate in public accommodations. That law was fought, that people did not like. A group did not like that law, and so it ended up in the Supreme Court to interpret whether it was okay for Congress to make that law. And the answer was yes. It's okay. The United States Supreme Court said yes, and its rationale was that it was free flow of commerce. Okay, so there are two examples. Here's another example of the Commerce Clause. The Commerce Clause comes along, and again, more expansive reading by the United States Supreme Court. We have times of war versus times of peace. That's the historical background of 1995. And so now we need to more broadly interpret search and seizure laws. And it is, and in this case, and I didn't cite it, but it's in the textbook. In this case, all these influences were coming into play, and there were concerns about search and seizure laws. And as a result of the interpretation by the United States Supreme Court, it was found that we may, during times of war, be more lax in looking at the search and seizure activities of the police. And, people don't always like these answers, and this is what raises a political question. And, by the way, I made the note of, it really expresses the interplay between the government branches. Congress says we can do this as far as search and seizures. Law A says we can listen in on telephone records, or on telephone conversations. But, and the United States Supreme Court in this case did. They said this is okay under these circumstances because times of war versus times of peace. Again, whether we as citizens are really happy with that, not always. But the conversation we're having for this purpose is to look at how society changes and how the United States Supreme Court and its makeup bring about different readings of the same clause in the United States Constitution. Alright, so that concludes those 4 pages, my discussion about those 4 pages of the textbook. And again, the ideas that that the authors are trying to convey to you are the historical challenges, the societal challenges, and the necessary and proper clause in relation to a clause. And in this case, the authors chose to explain it in relation to the Commerce Clause. And the Commerce Clause is very, very, and it's kind of funny. Some people that have been to law school kind of joke around about how the Commerce Clause is always being interpreted differently. So, but the necessary and proper clause backs up this, some of these decisions, many of these decisions, and we would find this in relation to many other clauses other than the Commerce Clause. This is just an example. All right? So next, we'll move on to the next slide, which is about state law. All right, state law are laws that must relate to the health, welfare, safety, and morals of the state's citizenry. It's that way because the United States Constitution says so. All right, and the United States Constitution says that the state may make its own laws related to the health, welfare, safety, and morals of the state's citizenry. State laws, however, can't violate the United States Constitution. So while the states have the power to make these laws that fit into that category of health, welfare, safety, and morals of the state's citizenry, they can't violate the United States Constitution. All right, so this is something where we come into the conversation of the state actor. And the state actor can be the state, as in the state of Florida, or the state of Colorado, or whatever. Or the state is also often referred to as the United States government. So when it's the government, that's what state means. Whenever you hear that terminology, they may not be talking about a particular state, the person that's speaking, the state can't make these laws. They could also be talking about the federal government. But in this case, state law is saying, in this presentation, and the objective is to help you understand that state law must relate to the health, welfare, safety, and morals of the state's citizenry, not another state, and that the laws that the state makes can't violate the United States Constitution. So while each state is free to create its own laws, they cannot violate the Constitution, and they can do more in the states. States can have a law that is above and beyond the threshold of the United States Constitution. And that's a really important principle to understand. That most of the many of the states do have greater rights than what the United States Constitution provides already. The United States Constitution sets a threshold. Now, next we go into the doctrine of preemption. The reason the doctrine of preemption is important is because, as we've discussed already, the states can make laws, and so can the federal government. And, as you know, there are situations where the necessary and proper clause comes into the case. But what's really essential to understand here is that the laws of the states cannot conflict with federal laws. I already pointed out, states can pass regulations or pass laws that create greater rights in state than they do at the federal government level. But the states can't make laws that conflict with federal laws. And it may mean that there may be a specific prohibition that makes it impossible legally for for the states to pass any laws on a particular subject. There are these would be set out in the congressional statutes. For example, Congress makes a law and it says the Congress will be the sole lawmaker in the area of widget manufacturing. It's just an example I've made up. And if that's the case, then the states cannot make laws on those particular subjects unless for some reason Congress has exceeded its powers and shouldn't have made those laws in the first place. So that's a different question. The point is that the doctrine of preemption is a legal doctrine that prevents states from passing laws that conflict with federal laws and permits states to make laws, but if it's already been reserved, if that area of law has already been reserved to the federal government, the state can't go there. Now, it's important to understand, and I didn't mention this in Chapter 3, I don't think, in my PowerPoint lecture, but I would like to point out that we have a lot of opportunities as states and as administrative agencies of states and of the federal government agencies to pass regulations and laws, in other words, authorities that don't conflict with federal laws. And we may need to fill in the gaps from time to time with state laws. So if the federal government has restricted lawmaking about the manufacture of widgets to Congress only, but the state has is providing the widgets are being made in the state of Florida, then they might, doesn't mean that, that all laws that have to do with every single thing that do with widgets are necessarily going to be that of something Congress has made. There may be state regulations that are necessary to fill in gaps that the federal laws did not include. So they can pass, the states can pass additional regulations that don't conflict with federal laws. And those are the three main points of doctrine of preemption. And I will point out also that there's an outstanding video that I put into this course about the doctrine of preemption. It has has really great music. It's really powerful music in the background, and it just is like a PowerPoint presentation with no voice at all, no lecture, but it's really outstanding and helps to understand this more, a lot more intensely. And it is a bigger project than I'm going to put into it right now, simply because that video will do it for you. It's a YouTube video. The doctrine of preemption prevents states, like I said, from passing laws that conflict with laws. The doctrine may prohibit states from passing any laws on a particular subject, and the states can pass those additional regulations. I may have duplicated that slide. I apologize. So what's a takeaway from this when we are researching? Well, first of all, we know there are federal and state laws, and we need to, in the classification system of how do I look for answers to this client's problem, or how do I look for answers to just learn about the law, I have to ask myself, is it state or federal law? And sometimes, as we are researching, we just necessarily have to ask ourselves this question of, does the doctrine of preemption apply? And because if I'm just researching in the state authorities that we talked about earlier, like common law or administrative law on the state level, or regulations of the administrative agency, and I'm not finding anything in the state, it may be that it's been preempted, that I won't find anything that the state has, there won't be any state law on this, because if they were only legislated on the state level, we have to research state law. However, if there are some areas where only Congress can legislate and there's total preemption, and so we need to research federal law. We need to go into the sources of law that pertain to federal, that have federal law in them, in order to research there. And then there are the other issues where sometimes, as I pointed out, there may be some state laws that fill in some gaps that the federal laws didn't handle, like Congress didn't fully handle everything having to do with the widget makers. So the manufacturers convinced their legislature of the state to make laws that help with their taxation, for example, the state taxation for sales tax, for example. So it does, just because something's been excluded to Congress may not necessarily mean there's total preemption. And so we need to research both federal and state law. And finally, whether Congress, a state, or both may legislate a certain law depends on what the law covers. And understanding the Constitution with the respect to the powers, and understanding federalism, and understanding how the Constitution has delegated to the states, or permitted the states to make laws in health, safety, welfare, and morals of its citizenry, helps to lead you to the right source of law to do your research. Okay? In conclusion, we've covered the federal versus the state law, looked at the classification of the law only between state and federal law. There are still the other couple of areas to go into in parts B and C, which cover civil versus criminal law and substantive versus procedural law. Recognize that many of the concepts come into play that we already talked about in Chapter 3, like federalism, like the sources of law, and what you should be starting to bring to your awareness is a knowledge of the different sources of law and how they fit into their classification. And as we move through the next video or the next lecture, I hope that becomes more clear. Recognizing that there are limits to the powers of the federal government, just like there are limits to the powers of the state government. Some of those limits are delineated in the Constitution, but the courts, because of societal circumstances, might very well find that they're implied powers because of the explicitly enumerated powers in the Constitution. And then again, there's preemption, which blocks states from making laws that are in conflict with federal law, and if they are, the federal laws trump the state laws. And if they aren't, we might have a situation where only the state legislated in that area, or only the federal, and then there are the situations where both state and federal may govern a problem. But just realizing at the end of the day, if there's total preemption, then there's a trumping of the state law. All right. Thank you very much.